I'm willing to bet that sometime recently you read an article about a legal dispute in which one of the attorneys or one of the parties to the litigation or legal dispute declined to comment publicly on it. In this video, I'm going to debunk the 4 myths that attorneys and clients rely on when they think that declining to comment publicly on pending litigation is a good idea. I'm Wayne Pollock, and you're watching Copo Talk. In this episode, I debunk the 4 myths that attorneys and clients rely on when they decide to decline to comment publicly on pending litigation. The first myth is that somehow what they're doing is consistent with their company's or the organization's ongoing communication strategy. That's a myth. It's just not right. Many clients, many companies and organizations, legal clients of lawyers, have public relations, marketing, advertising people who are working to build a connection between the organization and its key audiences, whether those are clients, investors, employees, the community, whatever. When an organization decides to decline to comment on a pending legal dispute and they clam up, now all that effort to build a relationship and to come across as transparent and open is all for naught. And attorneys and clients don't realize that declining to comment on pending litigation runs directly headfirst into this otherwise consistent history of communicating openly. And it could often do more harm than good when these key audiences who are so used to hearing from the organization now hear silence. And what's the first thing you think of when you hear silence concerning a legal dispute? Gee, something's wrong here. I guess what these allegations are saying really happened. That's the first myth. The second myth is that somehow talking publicly about the case will somehow make the case worse. That's a myth. It's not true. The conduct that gave rise to a legal dispute and the allegations in a dispute happened. It's done. It's said and done, and now the litigation is about dealing with the ramifications of those actions that gave rise to the allegations. Talking publicly about a case is not going to make it worse. So some attorneys may think that, gee, the other side will start doing discovery and investigating my PR efforts. But guess what? Those are easily objectionable and can be stricken because they're not relevant to the case at issue here. So the idea that talking publicly about a case makes it worse somehow is just not true. If anything, it's the inverse. Not talking about a case makes it worse because you as the attorney or as the client are unable to get your story out there and perhaps undo any adverse publicity that jurors may be listening to, that judges might be listening to, that other people who could affect the impact of the case or the outcome of the case are listening to. Third, the idea or the myth that attorneys' ethical rules prevent them from talking publicly about cases. That's a myth. That's not true. Most states follow the ABA Rule of Professional Conduct Model Rule 3.6, which simply says that attorneys can't make public statements that they know or reasonably should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding. On top of that, there are safe harbors attorneys can rely on to avoid prohibiting the rule. For example, attorneys can always talk about the claims, offenses, and defenses involved in their cases. They can also talk about the contents of a public record. In addition, attorneys can rebut negative publicity that was caused by the other side, whether it's the other side's attorney or the other side's client, as long as that rebuttal is narrow and limited to the substance of what the adverse publicity was about in the first place. So again, ethical rules, not a problem here. It's a myth that they prevent you from talking publicly about a case when you're an attorney, and they certainly don't apply to clients. Finally, the idea that if I don't bring this into the court of public opinion, if I'm quiet, so too will my opposing counsel. That's a myth, and that's not true. Opposing counsel can smell blood in the water. If they know that you, as the attorney or your client, is not going to respond publicly to allegations, they're going to pounce, and they'll turn up the rhetoric, and they'll turn up the pressure, and now you and your client are in a worse position because now you're behind the 8 ball, and there's been a steady stream of bad publicity about your case, or more disclosures about your case through the media or through social media or on other online spots. And now you're fighting an uphill battle that you might not have fought had you simply responded when you could have and not declined to comment. So there you have it. Those are the 4 myths that underpin a lot of the decisions that attorneys or clients make to decline to comment on pending litigation. If you know Copo Strategies, if you know me, you know our view. Always comment on pending litigation. You should be affirmative, not simply reactive. You should be actively engaging the court of public opinion and actively telling your client's story in the court of public opinion. If you've liked this video, please subscribe to our YouTube channel. Please check out our social media posts and social media feeds. The website is copostrategies.com. The blog is copacetic.com. And until next time, thanks for watching.